Hello, hello, hello.
Morning, Joe. Are you there?
Hey, good morning. Can everybody hear me?
Yeah.
Yeah, great.
Hi, Joe.
Hey, good morning.
Good morning, good afternoon.
Well, yeah, right. It's morning where I'm sitting in Denver. Although
Yeah.
it doesn't feel very morningish. It's already getting up to about 80 right now.
Oh,
Supposed to be 97 today before it's all done. So
oh, that's hot.
Yeah, Joe, how you doing? This is Harry Chupnick.
hey,
Fair question. I'm not too swift when it comes to cell phones and stuff like this, but basically the only thing I see right now is the bridge. Is that
yeah, I'm looking.
I'm
I'm
on
trying to
I'm
get
on the
my
right
camera.
thing?
Yeah, my camera should be working, and
No,
my eyes
okay.
keep shooting over my head.
Good afternoon, all.
Good morning. My camera's being goofy today. Let me see. Good showing today.
Good morning, Mr. Wickham. Jennifer
How are you?
Mateer here.
I know what's happening now. All right. There it is. It was trying to use my camera on my phone. My Apple and my Mac my phone and my Mac thought they were the same thing. So that's all fixed now. Now you can see me. Okay. All right.
I can see you now.
Yep. That's
You're
right.
okay.
We have a good group coming in today. I think that's because we've been sending out a lot of sworn statements, and I wanted to get everybody up to speed on that. Plus, we're about to file an amended complaint. I've completely briefed our appeal. Trying to make sure I don't leave anybody in the waiting room. I usually give everybody about a couple, 2-3 minutes to get into the room, and then I'll kick the event off. We'll get into updates about what's happening. We've got everything I need.
Is it okay just to ask like a real fast question?
Sure, go ahead.
Okay, basically, I can picture this taking a year, ballpark figure. Now, in between that, let's say somebody dies, which is as far as one of the claimants. What happens then? And we have to sign things. Would we get like a power of attorney or something like that? So our wives or spouses can sign for us.
What happens, okay, so at that point, and this, I'm putting on my trust and estates hat now. In that instance, your estate takes over in your place. So your estate would just, you want to make sure that any of your testamentary documents, will, whatever you have, or your somebody next of kin, whoever, knows that you're in this case, and then they would just alert, or whoever. I'm not speaking to you because you asked a question, but whoever the family member of whoever passes would reach out to my firm or to me. That's why I've created so many channels of communication with people so they can get through the portal, text message, email, and just let me know that one of the plaintiffs has passed. And then the estate steps into the shoes of the plaintiff in that instance. And then whatever, whatever award, whatever is from the court goes to the estate of the decedent.
Okay, great. Thank you.
No problem. All right, ladies and gentlemen. I have everything I need to get started this morning, except for a glass of water. So I'm going to step away for about 3 seconds, maybe 5, and grab a quick glass of water. I'll be right back. So the good news is I'm coming to you live from my bedroom this morning, which is I've got the Brooklyn Bridge. I think that's not the Brooklyn Bridge.
The Golden.
That's the Golden State Bridge. Yep. So let me see. Let me make sure I've got looks like Nina's trying to get in. That's a total of 26 now. Okay. All right. All right. Let me jump in. For everyone's knowledge and notification, this is being recorded. I'll do what I do in every instance. I will circulate the recording after we're done, and then I'll post it on the firm's website so that there's a permanent place for people to come and get it. But I want to launch into where we are. Let me see. I got to do 2 things at one time. I got to keep an eye on folks as they come into the waiting room so that they can get in. And Mr. Chutnick, I'm going to mute you real quick, and I'm going to keep everybody muted for this time being, and then we're going to open it up to questions. And we'll do what we always do. We'll do a Q&A when I'm done doing the update portion of the presentation. I would expect with the number of attendees who are here today, there's going to be a good number of questions. I've scheduled this for an hour, but of course it's my hour to expand or shorten it as I see fit. I mean, in other words, if we're not done answering questions, we'll keep going until we are. All right, so let me update everyone on where we are currently. So again, from the 30,000-foot view, I'm sort of answering questions globally that I've gotten over Teams, over text messages and emails, and it demonstrated to me that I haven't done a perfect job explaining everything that's going on in this case. So for those who are newer to the case or who haven't been to one of my webinars, this case was filed originally in January of 2021. It was originally styled Lambro versus the United States, and the only plaintiff in that case was Jason Lambro. The only defendant was the United States of America, but primarily with the focus being on USAGM VOA. That case moved through to 2022. The trial court dismissed that claim in its entirety, ruling that we had primarily argued in that case that the government had, and we pled it as a class, and we had argued that the government had misclassified a huge group of people at the VOA, and by extension had failed to pay them overtime and minimum wage. Overtime was, almost everybody that I've talked to who was in that 1099 universe was allowed to invoice for 40 hour. They were invoicing more or less by the day. Or a week or month, and they were allowed to invoice for 40 hours. They were put on an hourly rate. And this is what I knew about that in 2021. Anyway, the government moved to dismiss the claim, arguing that the government couldn't misclassify people because of Title V. And it's a really thorny, weird legal issue, but the trial court agreed with the government and dismissed our claim, and then I appealed it. That appeal went up to the Court of Appeals for the Federal Circuit, and then the Court of Appeals agreed with our position, which is that the under the Fair Labor Standards Act, an employee is someone who is allowed to work. The statute says suffer to work. We won that. We won that appeal. We went back down to the trial court, and we've been back at the trial court since June of 2024. I tried to amend the complaint. We have a judge in the case named Judge Summers, who, when I filed the motion to amend, he didn't deny it. He just rebuffed it, and then we ended up having to file a new complaint, which was styled after Michael Jordan and Sue Justice and Steve Justice and Marie, and there was about 8 people in that case. We went through motions practice on that case. The court again dismissed a bunch of the plaintiffs, didn't dismiss the whole case, but dismissed a bunch of plaintiffs on the basis of on varying grounds. For 2 of the people, they said that they'd done prior cases and there was claim exclusion, then there were others like Jordan and Green that the court argued or ruled their statute of limitations had told, even though they, and the court didn't even count the time we were up on appeal for the statute of limitations ruling. So he dismissed those claims. I again appealed. That appeal is all the way up at the Court of Appeals again. It's fully briefed. I think we're on more solid footing than we were on the first appeal. But in this instance, one of the things we're appealing is that the statute of limitations never started running because the plaintiffs were never in a position to know. They were never in a position to know that about their rights. And the argument that I raised there is that the court that we're in, the Court of Federal Claims, actually affirmatively ruled that the rights that we were trying to protect did not exist. So that's up on the Court of Appeals, as well as I brought a retaliation claim in that case for the state against the State Department on behalf of Jason Lambro, and the court the court dismissed that claim, ruling that the Court of Federal Claims did not have jurisdiction over the claim, having to do with a very convoluted provision in the organic statute at the Court of Federal Claims. And again, it's really legal morass that I don't need to bog you all down in. We knew that the court was wrong, and we appealed that ruling, and that's also been briefed. Now, the argument, again, I'm not, without bogging you down and make you all go to sleep, the argument that the court advanced was the retaliation claim was a claim born in tort, and the organic statute of the Court of Federal Claims expressly excludes claims born in tort. My argument in response was, well, what the court missed, what the previous courts had missed, is that there was an amendment in 1977 to the Fair Labor Standards Act, which is the statute in which we're in this court. And what I argued is that claims born in tort are things like intentional infliction of emotional distress, claims like fraud. This, we argue, was a garden variety violation of the Fair Labor Standards Act statute, which says you can't fire or harass anybody because they have filed a Fair Labor Standards Act claim. Now, what many of you may not know, many of you know, or all of you know at VOA, that there was a big layoff at the end of May, or termination at the end of May 2025. What some of you don't know, I know Michael Jordan knows, I know Jason, because they were in the courtroom, but I was doing oral argument in the Court of Federal Claims for this case on May 7th of 2025. So 2 weeks later, 2 or 3 weeks later, they turn around and fired everybody. And that fits. The reason that's important is because of a doctrine referred to as temporal proximity, which means that if you're fired within a short period of time from a protected action, which in this case was arguing your case, then the court is required to assume that the two things are related. So that's where we are on that. Now, one other thing that I want to address is that I've gotten a few emails, and we're going to hopefully get to talk about this today, but I've gotten a few emails this week specifically, and I've had some allusions to this in these meetings that didn't really come clear to me. There's an outfit called Gilbert, I think Gilbert Employment Law, that is sending people into emails, soliciting their business to do what reads like a retaliation claim at the Court of Federal Claims for the firing at VOA. Now, what's important for everyone, everyone here should know they can always pick whatever attorney they want to pick, whether it's me or whoever, right? But the one thing you ought to know is that the retaliation claim is already in front of the court and already in front of the Court of Appeals. And that's the very claim that Judge Summers rejected as not fitting within the court's jurisdiction. So what I'm trying to do is get the Court of Appeals to rule that it does fit in this court's jurisdiction and that it's the only mechanism by which individuals can get full compensation. If they were forced to move, as Judge Summers has argued, to move into another district court, like the U.S. District Court for the District of Columbia, I don't know why that's happening, knock it off. I'm going to turn that off. That is actually the Democratic Party trying to lose its mind right now. Apparently there was the senator from Kentucky passed last night. So anyway, the argument what I'm making is if you're forced to go to the U.S. District Court for the District of Columbia, then you're limited to $10,000 in compensation, and that is not what the that is not what the court. I'm sorry, that is not what Congress intended when it changed the provisions of the Fair Labor Standards Act in 1977 to give people the ability to get compensated for being fired. So what I'm trying to say, and the other thing that strikes me about someone was kind enough to send me the letter from Gilbert, is that they're asking for $405 filing fees so that they can basically, I think their goal is to file 1,000 different individual claims at the Court of Federal Claims and then join them down the road. You're already joined. You're already in this case in the collective as an opt-in. The court will likely accuse whoever is already in both cases of claim splitting, which is something that would be grounds for dismissing the new claim. And if you're dismissed for claim splitting, the $405 that you filed to get into the case is gone. So, and I was a little shocked that they would want to try to file, 1,000. There's no reason to do that under Rule 20 of the Rule 20 of the courts of the rules, Federal Rules of Civil Procedure, or in this case, the Court of Federal Claims Rules of Civil Procedure. So I'm not here to tell you who to pick to be a lawyer. I will tell you that we're already litigating the issue of retaliation for everybody who's already in the case. That's already being litigated. And that's been litigated since 2024. That was actually starting to litigate before the firing took place in 2025. And we have, I'm filing an amended complaint right now. And that retaliation issue is already in front of the Court of Appeals for the Federal Circuit. Now, the last thing I want to tell you guys as far as the other things going on is that about a month ago, I got all of what you guys have also filed, which is Federal Tort Claims Act packets, which is a separate body of law that holds the government accountable for violating state law. And what I've gone through now, a subset of you qualifies for that. Anybody who is wrongly classified as a 1099 versus a W-2 qualifies for this state-based claim, because in virtually not all, but about 48 states in the union that I have found have actual laws on their statute, on the books, that say you're not allowed to classify a W-2 employee or someone who should be a W-2 employee as a 1099 as a means of trying to escape things like paying self-employment, paying the 7.65% FICA. Also almost every state in the union has rules about, like in Colorado, you're required to give every employee 2 weeks of, or it's like, I think it's like 40 hours of sick leave every year, some amount of personal time off, or vacation pay. They're required to provide health insurance. All these different states have different laws about that. And so based on the state of residence for each of you that have signed up, and most of you did, I think I had like 280 people fill out sworn statements. We found about 85 of you or slightly more than that, maybe 85 to 90 of you who actually qualified as, who had asserted they were misclassified. Now, the normal statute of limitations on that is 2 years, but I'm using the same equitable estoppel, equitable tolling, and accrual suspension rule to argue that the statute of limitations should not apply to people who had no way of knowing what their rights were. So that's a 19-minute catch up, maybe 17-minute catch up on where we were on the case. I'm motioning the court to add, I think there were 3 more VOA people onto the case. One of the things that I don't even think Jason knows, and I think he's on this case, is that when the court dismissed the retaliation claims, it also inadvertently, because when I figured out this last week, it also inadvertently dismissed Jason Lambro's wage and hour claims against the State Department, which I had also pled, and it didn't. No one had argued that it should have been dismissed, and the court just missed it. So I'm raising that to the court in this instance, that it didn't actually dismiss Jason's claims. It just, when it ruled that I had to file an amended complaint only naming the justices, that it forgot that Jason also had a wage and hour claim in there. So that's where we are now. I've said a lot of words, and it's been about 20 minutes. I'm going to open it up to questions the way I'm going to do it, the way I always do. I'm going to rely on the software. When someone raises their hand, you can use the little hand raise button at the bottom. I'll go in the order that I see the hands raised, which in this case is Ngadu. I'm going to hopefully try to do my best on names. Ngadu Wandibu.
Yes, that's correct. Thank you very much for the update. From what I understand, as you tell us every time in this meeting, your case is misclassification, over time and whatnot. And Gilbert's case, as I understand, is they're seeking damages. They are seeking the lost income because we are terminated. So will participating in one case affect the other? Or to be specific to you, if I participate in the Gilbert's case, will it affect my relationship with you? Or will the court say, oh no, you are in this case already, you can't double dip? Can you respond to this?
Let me make sure I understand your question correctly. Did your question have anything to do with the Gilbert case or the
yes.
folks?
Yes.
I want to make sure. So that's the question I thought you were asking. So the answer is there's a doctrine, and you can Google it. It's called claim splitting. You can't have 2 separate pieces of litigation going in 2 separate, and I say courtrooms, not even courts, not like Court of Federal Claims. You can't have cases down the hall from one another that both relate to the same facts. And so if you have a case with the Gilbert, let's say, and by the way, if the Gilbert law firm files a lawsuit right now in the Court of Federal Claims, arguing retaliation under the FLSA, which is the only way you get into the Court of Federal Claims, is you have to argue that they violated a statute, which in this case would be the Fair Labor Standards Act. You can't bring a garden variety tort to the Court of Federal Claims. It doesn't have jurisdiction over FTCA claims. It's a court, what's called a court of limited jurisdiction. So you're allowed to bring cases into that court for which that court was created. The primary thing you're allowed to bring into that court is instances in which the federal government has breached a contract. That's under what's called a contracts dispute act claim. You can bring bid protest for cases you should have, but and the other one is when the government violates one of its own statutes. And in this case, we've argued that the government has violated the Fair Labor Standards Act, and you get there under what's called, and you can write all these things down, or you can wait for the recording to come. But it's called the Tucker Act. There's the Big Tucker Act and the Little Tucker Act. The Big Tucker Act is the way you get into the Court of Federal Claims. And there's no cap on the amount of compensation you can get from monetary compensation. Again, the government in the Court of Federal Claims is immune from suit for things like intentional infliction of emotional distress, or things like that. To get the government for things like that, you've got to go through the Federal Tort Claims Act, and you've got to find a state statute that they violated. And so if you were to join the Gilbert case and you were already in my case as an opt-in, then what the court ought to do is look to see what issues were pled in this court, and if there's an overlap of pleadings in the new court, it should dismiss the pleadings in the new court under the doctrine of claim splitting. And believe me, the entity that's going to be filing that motion to dismiss on the Gilbert claim is going to be the Department of Justice, who is intimately familiar with who is in this case and what issues have been pled in this case. And then the $405 that was used to file the case to get in is lost. There's not going to be any reimbursement of that $405, which is why I think the law firm, this is speculation, I don't know, I haven't spoken to anybody at that firm, is asking for the $405 in advance, because that's their money at risk if they were to pay it themselves.
Are you planning to speak to them? Maybe have you talked to them so far?
So it would be improper for me to reach out to another law firm and tell them, that what they're doing is, in my way of thinking, ill-advised. I don't, for example, I haven't seen any of their pleadings. I don't know what you're trying to do. I haven't looked to see if they've actually filed any of these cases. I'm perfectly comfortable with educating my clients and people who are thinking about joining that case. And so I make these webinars are publicly available. And when people have reached out to me about this Gilbert case, I let them know that case is already filed. So maybe there is a universe where they know. I have a hard time imagining anybody knowing how to move around in the Court of Federal Claims better than I do, but I can just, suspending disbelief. Maybe they have come up with some creative way to get in here, but the only way I would know that is when I see the complaint they've drafted. So if anybody gets, what they should do, if they're going to sign you up an engagement letter, they're going to file a complaint in your name, and they should allow you to see the complaint before they file it, before they spend your $405. If they do send you that complaint, it's perfectly legitimate for you to get a second opinion from somebody who looks like me or somebody else who's good at moving around in the Court of Federal Claims, and ask them to review the complaint and to advise you as to whether or not this is a good idea or not.
So are the damages they're seeking also included in your case? I had difficulty of the audio here. So are the damages they're trying to seek is also covered under your case?
Yes, we're trying to cover pay backwards and forwards. So meaning all of the overtime and minimum wage pay that you weren't paid in the past before your termination date, and all of the money that you should have been paid had you not been wrongfully terminated. That's what we're trying to get going forward. And by the way, anything we're trying to get times 2. So that's what's called the liquidated damages provision of the Fair Labor Standards Act statute. So if they shorted you, in many cases, I've been using like a round number of $40 an hour, which means you were due $60 of overtime. Most of you weren't even paid the $40 for the time you worked over 40. You were paid $0 for any time you worked overtime. So I've calculated that you're due, in that $40 an hour instance, $60 per hour for every hour you've worked overtime. And then anytime that you weren't paid at all, like some of the Social Security folks were in the hearing offices not being paid at all, I'm arguing they should have been paid their average hourly rate for all of that time, and in excess of 40 times 1.5 times 2. And then again, if you were terminated I'm arguing that if you were terminated, it was because of this case, and if the court buys what I'm selling, then then you end up getting all of your future pay, meaning any pay you would have been paid if you'd not been fired minus whatever you're getting paid in a new job. So if you were fired from VOA and then you landed over at CNN or Fox News or some other news channel, and they were paying you more than you were getting paid at VOA, then the damages would be the amount of money for the amount of months you were out of work. If you're being paid less, let's say you were being paid, $40, $80,000 a year at VOA, and you got a job for $60,000 a year, then your damages end up being $20,000 a year going forward for however long that difference remains. So that's what we're already trying to accomplish in the current case, and that's the way it's playing. Does that answer your question?
Thank you.
Okay, great. Ignatius, your hand was up next.
Hi, good morning, Joe. Can you hear me?
I can.
Thank you for the work that you do. I have two questions. One, today is exactly a month since you filed the form, I believe, Standard Form 95 with the VOA and other agencies,
Yes.
by which they have 6 months to get back to you. I'm just wondering if you've had anything at all from them as far as receipts of the forms are
Not a whisper.
concerned. And
So
I'm sorry.
let me answer that question first. One is not a whisper. I did send I spent a significant amount of money sending all of those FedEx so that I have confirmation that of when they were received, and that is the only thing we're charged with caring about. I have receipt for when they received them.
Okay, all right, thank you. And then two, the other time I was trying to track the portal to send you a message, and it was hard to find that on the emails and even on my laptop. Are you able to show me how I can navigate locating the portal?
Yes, that is a fantastic question. Let me sign into Clio, manage, and I'm going to do a couple of things. So first, it should hit your inbox, and the search would be to search for Clio, because it's going to come up as a man alive. What is that? I get frustrated with my computer when I'm trying to type and talk at the same time. All right, here we go. I'm going to send you something. Wait for my two-factor. And then the other way, remember, the other way that I correspond with a lot of you is through the text messaging, which that should hit your phone. And I don't want to, there you are. All right, so I'm going to send a communication right now so that, actually, it looks like you sent me something in June of last year. So, and that's what I like about this portal, is that your most recent communication comes up on here is not the client portal. Now, if you were trying to add something through NetDocs, which is another thing that I have created for you to like drop documents, I will go into that and send you another link there. And then you can, now that should have just hit your inbox. Let me go into your collab space, which is another tool we use for this is just I've got a good number of documents from you in here, and from
Yes.
so that should be good. Now, the last thing, and this is kind of just a PSA for everybody who I'm doing business with, that I'm about to send you a text that says, "Hey, this is Joe," and then you can save that in your phone as kind of your bat signal. Anytime you need me, you can text me on there. You can send me documents that way. You can send me documents that way also. The weird thing is, or maybe not so weird, I cannot send documents back to you that way. I can certainly share documents through the portal, which I've done with many of you, but I can't send anything through text. But I can send, I don't know that you'd want me to, right? But I can send it through the portal, which should hit your inbox. And then and you can search it through looking for CLIO. And that is where your document exchange and things like that are. Did that help out, Ignatius?
It did, Joe. Thank you so much. It's received.
All right,
Both the
perfect.
text and the email. I appreciate it.
Of course. All right.
Okay,
Let me
all
go
right.
to Jody Melton. Go ahead.
Hi, Joe. Is there a list of that inventory of documents that are helpful for us to start collecting? I'm new to the.
No, I appreciate that. That's an excellent question. And the answer is no. And here's why I'm saying that. Like, I'm intentionally avoiding sending the signal that I need something from you that without which I won't be able to advance this case. There have been many of you who have written me like, Joe, I don't have anything. I'm like, don't panic. It's fine. I haven't even started discovery with the government yet. And when I do discovery, I'm going to be the most advantageous thing about, first of all, let me answer your question precisely, Jody. The things that would be helpful are basically just exchanges that you had. Let's say you were classified as a 1099, right? Email exchanges, things like that, text exchanges that showed that the government was, really in control of what you did, where you worked, those kinds of things. Any evidence that you have that you worked hours outside of normal business hours. Now, a lot of people are like, well, I don't have anything. And I'm like, if forensically, I could come up with this stuff. So and this is why I'm not that worried about it. One of the things I'm going to hit the government when it comes to discovery is, almost everybody that I'm aware of that's connected with this case used a government logon to get into their computer and software. Like most people had CAT cards, had ways to get into computers. They carded in and out of the government buildings. Many of the Social Security people, I'm pretty sure, if the life is still the same as when I worked there, you signed in and out. There are going to be assignments that showed a lot of the folks at VOA had what I call like an off-campus assignment. You were sent somewhere to go cover a story, and literally none of this time that I found. This is one of those things that kind of think falls into the sort of mental gap because you're so used to doing this kind of work that it doesn't occur to you that when you're traveling for work, you should also get paid because you're not being reimbursed for that time. If you're being taken out of town to go cover a story, you should be getting paid something for that time that you're in. It may not be your full hourly rate, but you should be getting compensated something while you're out of town. You should be getting per diem for the meals that you're eating. You should be getting, all of these other things. Also, a lot of folks that are in the sort of creative side of the news production, whether you're doing audio, video, you're editing, every person I know, honestly, I mean, almost everyone I know that does any kind of creative work for a living spends a lot of their off hours preparing for the next day, doing, editing the work they've already done, planning their next day. And almost none of that is captured in their hours that they present to the agency. So the short answer, there's much shorter answer to your question, Jody, is anything that you have that demonstrates that you worked and you did work for which you weren't compensated, or that shows that the government exercised control over you. Another one that comes is useful. And again, it could be email exchanges, text exchanges, it could be documents. I have lots of copies of contracts, for example. Some of the contracts themselves are offending contracts. I mean, they break the law in their face. I've sent several of you copies and paste from contract provisions that said VOA is a 724 news agency, and you're required to do. You're required to be able to react, and it basically says you have to be available to do news stories 7 days a week, 24 hours a day, including government holidays, and that means I translate to say that you're basically on call all the time, or at least you have to be available to be able to go and do a story. And the fact that the government uses the word available, that availability is problematic for the government because you should have a reliable schedule that you can take time off around, but and especially if you're an independent contractor. So any of those types of things, Jody, are just very useful. Also, what you don't have, there's an assumption in employment law that when we're doing this kind of work, that almost all of the evidence that we will need to make the case against the government or the employer is in the possession of the employer, right? We already, and what they don't have, what is their problem? what they don't have means that your sworn statement is basically the only uncontroverted evidence that we have of what happened. Does that make sense?
Thank you. Yeah, thank you.
All right. Vanessa, is your hand still up, or did you have another question?
Sorry, I forgot to lower it. My bad.
No worries. I just want to make sure I'm not missing. Okay. Let me see. I don't see any. Oh, I got a couple of people who I haven't allowed into the room. Let me get that done. All right. And Michelle. All right. I've allowed some more people into the room. So let me update. So I've updated everyone while there's a pause and you guys are scratching your heads and thinking of new questions to ask, which is great. I'm going to update you on what is happening moving forward, because I get a lot of those questions. What's next, Joe? What's next steps, right? So, what's happening? The very next thing that's going to happen is I'm filing a motion to amend the existing complaint in the Jordan Justice case, right? And that is I'm adding I'm adding Jason back into the case, and I'm adding 3 or 4 more VOA people that were have damages between after 2021 or within 3 years of when they filed. This is all stuff that comports with the judge's current order, and the utility of that is once the court, what I expect will be months from now, grants the motion to amend the complaint, and we can then start the discovery process about the rest of the rest of the VOA offenses, right? And there's a lot. Like, I'm going to be asking for, once we get into the discovery there, I'm going to be asking for the names of everybody that was a 1099, a names, address, last known address, last known phone number for everybody who was a VOA USAGM 1099, going back to forever. They'll probably argue against it, but I'll get a good list of folks that I can then send out more information about this case. That's the other thing that you guys can continue to help me on. We have over 300 people in this case right now, and we've done that without any assistance from the government. Everybody who's currently in this case has come in by word of mouth. So if you know someone who has been, who's harmed by the government's practice, and they haven't, and you don't know whether they've joined the case or not, just let them know the case exists, and let them know that, and we can use that. The easiest way to get them in now is just to use that forum link that I've sent around, a million different times, that people can use to, when they send that to me, they, I get all their information. I'm able to incorporate all of that into an engagement letter and a sworn statement, and get their, if there's an FTCA action, I can get that filed, so we can add more people, which again puts more pressure on the government. But once I get that motion to amend filed, there will be some motions practiced. The government has already signaled that they oppose it, and then hopefully, I think this fits neatly with what Judge Summers has already ruled. Judge Summers hasn't done anything with the opt-ins, and he's obligated under the law to do something with the opt-ins. He hasn't dismissed any of the other opt-ins. The courts have signaled there's there's over almost 300 people that are currently in that case. So we're going to try to get discovery on that. And the other thing, and I'm in the discovery process on the Lambro VOA case, which again goes all the way back to 2018. So I should be able to use that case to go back and get things like to find out what forensic evidence exists, like, all the logins, all of the different exchanges that they had. I mean, there should be cat card logins, there should be, sign-ins, there should be assignments, there should be all of those things that we should be able to use to show that the government was fully aware that folks were working in excess of 40 hours. Because the response that the government has given so far on the Lambro case, on Jason's case, is, well, we paid him when he invoiced. And we're like, sure, but that's because you contractually obligated him to not invoice more than 40 hours in a month. You expressly told him he could not. In fact, you actually went as far as to say you couldn't have one contract provision said you weren't allowed to invoice in excess of $3,500, which is a clear violation, which was not accidental. That ties to the micro purchase threshold, which again, they were doing to keep to keep everything that we're doing invisible. Because, and that may not make sense to you guys who don't do a lot of government contract work, but in the universe of government contracting, anything that exceeds the micro purchase threshold is required to be publicly reported on a usaspending.gov website for the public to see, for taxpayers to see how the government's spending their money. If you keep it under the micro purchase threshold of $3,500, which is what it was back then, it's $10,000 now, but it was $3,500 back then the government doesn't have to report it. And there's like several $1 billion of unreported activity not within this VOA case, but within the federal government generally. All right, Nazanin Stefan asked a question.
Yes, hi. As we progress, I remember lots of things that I forgot to mention in the beginning relating to the report that you asked us to write about our contracts, our hours, and everything. Sure. Can we still update, send you new stuff?
Always. So the answer to that question is always, and actually we're obligated under Federal Rules of Civil Procedure, Rule 26, to continue to update our discovery. Now, discovery hasn't even started. So you're nowhere near, you're not even at the starting line yet for when discovery is due. But yes, so the sworn statement stuff, guys, just so you understand what we're doing, is I've pled an issue that's called pattern and practice, which means Jason, Michael, these were not outliers. These were not people that were singled out for the offensive behavior. This is something that the government did, or that the VOA did, VOA wide. So the sworn statement is helping us to get to the stage called certification, which is to show that all the people in this case are similarly situated sufficiently. I know it's a lot of alliteration. Similarly situated sufficiently that the court can try all of their issues together. Now, what that means is, as far as there's two parts to every legal case. You're getting like a little mini law school class here. There's two parts to every legal case when you're suing somebody. The first piece is liability, which is code for, did the person have a duty of care that they violated? Did they owe you a duty of care, and did they violate that duty of care? In other words, was somebody in a car universe, like was somebody obligated to look where they were going? That's a duty of care. And did they fail in that duty of care? That's the liability piece. In this instance, the duty of care is the government, that any employer is required to pay you time and a half for any time that you work above 40 hours, unless you fit into some really narrowly construed exception, which the government has not argued you fit into. The government has not argued you fit into an exception. Their first and only argument was, we don't owe you overtime because you were 1099s. Now, as it relates to the folks that, like a bunch of PSCs who have come into this case, almost a few I haven't seen too many GSs, but there have been a small number of GSs, a lot of PSCs who have moved into W-2s in the VOA side. And in those instances, what they've done is they told a lot of folks, hey, if you work 50 hours this week, just take 10 hours off next week. And a lot of folks are like, oh, that sounds great. I get some comp time. The reason that is illegal is that the time that you work for, over 40, you're due 1.5 times your pay. And when you take time off, you're just getting 1 for 1. You're just getting regular time. You're just getting, if you were making $40 an hour, you just get basically 40 hours of comp time. It's not 40. It's like they're going to pay you for the 40 hours. So you get the $40 you would your normal time, but you only get time and a half. So you're forever short of the time and a half. So what I was getting at is that you've got this liability, and then you've got the damages piece. Okay. I'm trying all of your liabilities together. So we're showing that the government has broken the law and that they've created damages.
Yeah.
Calculate your damages individually. And that is when we'll get into more granular level of detail. We've advanced the theory that you work 10 hours of overtime, for example, on average. If the government can't come up with something that disputes that, then that will be the basis of calculation of damages. If you come up with more, if you show like, hey, actually, like when one person told me that during a presidential election, for example, they worked like, virtually 16 to 24 hours a day. In that instance, that would be a spike during that time period when they should have gotten more money. And the short answer to your question is, I will always accept more evidence from you, because it's going to create that avalanche of evidence that's going to help the government, basically eventually wise up.
Also, excuse me. Also, when we worked overtime and in the same pay period, excuse me, in the same pay period, if we had like vacation day or if we had a sick leave and we had overtime, like in one day we work 10 hours, so we have 2 hours of overtime.
Yep.
If we take a vacation, they don't pay that overtime. They say because your actual in-office time was not 40 hours to be qualified for that 2 hours because we had one day off or one sick day.
And that's part of the illegal pattern and practice.
Yes.
Because a sick day is or a sick day or a vacation day is compensable time, and the 10 hours that you worked over it should count toward your 40 hours. So that again, that's just one of those other instances where when you send me these narratives, and especially that's why it's so useful to use the portal, because then I'm not fishing around through Outlook to try to find what stuff is done, or if you have an email exchange that you can download and save into the portal, that becomes very useful.
And also this 1099 on call that you mentioned in that statement 24/7. I don't have my old contracts when I was on 1099. I don't know where you have, I don't remember the details. Is that something that they mentioned in our contracts?
Yes, there was an addendum in the contracts, and I've actually been able to find them. Ironically, I've been able to find some of this language on what's called sam.gov, what used to be FedBizOps.
Oh, yes, yes.
So I've been able to find some of this contract language there. Some of it has been provided to me by workers. But this big, bold statement, it appeared in an addendum to almost all the contracts that I've seen.
Okay, great. Thank you so much.
Of course. Now we've got, I'm going to try to say it, Nita Maski-Tarini. And then I'll go to Jennifer next. Nita, what was your question? And if you're trying to talk, Tristan, you're still muted. There you go.
Hi, Mr. Whitcomb. I have a question. Is this lawsuit currently involve only minimum wage and overtime and not self-employment tax? Because I remember while watching one of your webinars, you said that minimum wage and overtime would be something that would go to the federal court, and the self-employment tax would be handled in state court, and that it would come later.
Well, so the state court claim is the one that we've recently just filed. That was the FTCA action that you guys filled out FTCA packets for. I can look after to make sure that you were included in that list, but I'm pretty confident that you were. So here's the thing. I have pled at the Court of Federal Claims that part of the damages for misclassification was the time and a half, the overtime, and I've included a pleading that said that the government didn't do your self-employment matching, the 7.65. I've pled it in both places. I pled it at the FTCA and at the Court of Federal Claims. The FTCA, like I said, that's at the agency right now. That's going to take 6 months to get back, and then, look, if they don't come back in 6 months, then I have an invitation to the court. I can go into the court and file it. I'm expecting what I'm going to do is open up my mailbox here in the near future, and it's going to be like 100 of these things telling me that I'm out of my mind. But that's fine. Then we can go straight to the federal court, because as soon as they deny the claim, then the new 6-month starter gun begins, in which I have to file in the court. I have to file in federal court, and again, I'm going to take what will probably end up being a half a dozen or a dozen federal courts, consolidate the filings into one action each, and then that makes it more efficient is what I'm trying to say. But yes, the short run is we've pled it in both places.
Okay, because the reason I ask is I did not do overtime, or I don't know about the minimum wage. But I was on 1099 for a long time, and I paid self-employment tax for a long time too. So if I have any interest in joining this lawsuit, it would be for that.
Yeah, so there's a minimum wage in the state-based claim. You've got the minimum wage, which is for time again that you were doing work and weren't paid anything, right? That would be like what off the books work, preparing, doing whatever. But also the 7.65 self-employment tax. In some states, it is a tort in and of itself to misclassify someone, because again, you're in almost all the states that I'm aware of now. There's some in Colorado, as an example, like I said, there's a minimum. California, Maryland, Massachusetts, all these different states, and Virginia, I believe is true. There is a requirement that anybody that should be qualified as a W-2 gets classified that way, because think about things like workers' compensation. This is something that came up in Jason's. If you don't have workers' compensation, you get injured on the job, you're exposed, right? You don't have medical benefits. You don't have FERS. I've pled at the state level. I've pled the FERS contributions. I've pled all these things that you didn't get by virtue of the fact that the government misclassified you. And again, they exposed you massively by not even carrying workers' compensation on you. Which means if you slipped and fell, if you slipped and fall in the government's parking lot, you could bring an FTC action like you could anybody else. But you would normally be able to bring a workers' comp claim, which means your medical treatment would be covered immediately. And again, they shorted you that. They shorted you, retire 401k or what they call thrift savings plan contributions. They shorted you all of those things. On top of the 7.65. So we've been global about all of that to make sure everything that you were shorted by virtue of being a 1099 is incorporated on that, and the minimum wage and the overtime. The state-based minimum wage issues are higher, and any damages that we figure out that we do is multiplied by 2 in some instances, 3 in some states. There's where you can get into what they call non-economic damages, which is sort of what you think of, which you probably heard of if you watch TV, like the pain and suffering type of damages at the state level.
Yeah, and would it go retroactive to when I started in 2001? I started in 2001 on 1099.
So this is what we was talking about at the beginning. This is one of the things that I'm arguing at, and I'll get to argue at each of the courts. Those fall under the doctrine of equitable tolling, equitable estoppel. The equitable estoppel basically means, hey, government, if you have been holding out that these people don't qualify as W-2s, or then you don't get, and the contract expressly stated, you may not hold yourself out as anything other than an independent contract under threat of termination for default. Then I'm arguing that, hey, you can't now raise the issue that these plaintiffs should have known better and brought a lawsuit, because your argument was they're not entitled to anything. In fact, the government went as far as to say it was impossible for them to create an employee-employer relationship through contract, because they felt like they were immune from this. And that's not a straight-faced reading of the statute. And the Court of Appeals in this instance has already agreed with us. So that's a long-winded way of saying everything I've pled and everything I'm arguing is in the name of going back as far as the law will allow me. And if I get back to 2001, that's fantastic for everybody involved.
And also in 2015, I think, the 1099 people were put on W-2 through a third party. We were given some benefits, but not like a full-time employee. So what's your argument for that?
So I've already pled that also. That's called a constructive violation of the Fair Labor Standards Act. So what happened with these contractor claims, like some Techniarts is an example at the VOA, and some others. So those folks, basically they said, hey contractor, you go get us 20, 30, 40 people, and they're going to work for us, and your job is to pay them. The difficulty is they put all of those people on firm fixed price contracts, which means if you worked overtime, there was no way for them to bill the government for the overtime that you worked. So the overtime stuff still ended up getting shorted. Also, a lot of the people I'm picking on Techniarts because I know about them, but they also put a lot of these people, like I know that Carmazzi and some other, they all put people on, 1099s and some other folks, which means they were also violating the FLSA. But my case against the government is you engineered this system that resulted in people not getting paid their overtime, their benefits, all the things that they should have gotten paid. So I'm making the government still liable, even though you were working for a third party. And not everybody moved. A lot of people, even after 2015, were still on directly contracting with the government.
Okay. Another question is, earlier you just said on this webinar that it may not be a good idea to file the Gilbert case because it's going to be not so good for us. How do you explain that?
So yeah, so if you file, there's a doctrine again. I'm hoping you'll write these things down and you'll Google them after to fact check me when we're done. But there's a doctrine in the legal business called claim splitting. So that means you're not allowed, if all of your claims should have been included in this particular case, then it's not okay to go out and file another case. In this instance, the claim is in this case. Now, if you're not in this case already, there's no, you can go file with the Gilberts, but the difficulty is the Gilbert firm is about to file what I would classify as a retaliation claim, because they're only looking at the firing. The letter that I read says they're only looking at the firing that happened in May of 2025. I've already got that issue alive, pled, and argued and at the Court of Appeals. If they file a retaliation claim right now saying that you were wrongfully fired because of your involvement in an FLSA action, then the court's going to kick that because they already have. They're going to dismiss it with prejudice, and then you'll end up having to go up to the Court of Appeals, which I've already done. And it's already briefed, and it's already, I'm waiting for oral argument, which is something I want to address before we get off. But does that answer? And they're also asking for $405 from every person, which is the filing fee at the Court of Federal Claims from every person.
Yeah, I haven't joined any of the lawsuits, yours or the Gilbert case. I was gonna do it today, but now that I've heard from you, well, I'll have to think about it.
All right.
And sir, one last question: what's the deadline to join this case?
So if I'm successful in getting people, what the court will likely do, Nita, is they'll look at each individual. If I succeed on this at this argument at the Court of Appeals, right? And what the court will likely be forced to do is look at when people join the case and ask the intelligent question: when should Nita have known about this issue? And if the answer is June of 2024, when I went back to the trial court, which I would argue maybe yes, maybe no, then they'll say 3 years from when that happened, right? In order for you to reach back in time for the 3 year statute of limitations, especially to go back in perpetuity. That's the end I'm arguing feverishly for, and argued with thousands of pages of arguments not thousands of pages of arguments, thousands. And appendices and things like that, evidence to try to prove that you had no way of knowing about the case or the existence of your rights. So I would say that the sooner you get in the case, the farther back in time that we'll be able to go to get you compensated is the short answer.
Okay, so after I sign the engagement letter, what's the next step?
Then I'll get, if I don't already have a sworn statement from you, I'll get one. I'll get any evidence from that you'll be in the case. I'll file it as soon as I get the signed engagement letter and the opt-in. I'll file that with the court, and you're in the case. And then you're just in the same, you're on the same bus as everyone else. Any documents that you have that'll be helpful, I'll incorporate into the case. But again, I don't need anything. I just need your story. That's it. Your individual story about what happened.
So a sworn statement, I have to write that and give it to you?
No, I will send you a form you'll fill out, and then I'll take that form and incorporate it into a sworn statement and send it back to you for signature.
Okay. All right. Thank you, sir.
Of course. I think Jennifer was next on my list of questions.
Yes, good afternoon, Joe. Thank you for taking my question. This is just real direct and to the point. All of the FSLA forms have been completed, and I wanted to understand, have they been submitted or they're going to be submitted?
I'm
Where are we on
submitting them.
that?
So that those FLSA sworn statements are going to be part of what I hope you were on the call. I talked about what's called a motion for certification. So that certification legal question is like, hey, court, I need you to take notice that all 300 people that are in this case are similarly situated, meaning they've suffered the same kind of harm. And these sworn statements that you've all completed have all shown that you basically suffered the same pattern in practice as everyone else. Now, the amount of harm will vary person to person, but the kind of harm will be the same. So the answer to your question, Jennifer, is I'm filing the amended complaint this week. The very next thing I have on my agenda is the motion for. I've already filed a motion for certification, by the way. I filed that in June of 2024, or August. Let's call it August of 2024. The court has never ruled on that motion. I'm going to file a renewed motion for certification once I get because what has to happen is the court has to grant my motion to amend, and then we'll get the motion for certification. And in that motion for certification, I'm going to try to get all the VOA, all the Social Security, all the State Department, everybody. I've got all the USPS, all the people that qualify under these different agencies under the same tent, so that we can. And the idea is to have a more efficient adjudication of all of these claims. The court can make one determination that yes, the government is liable, and then we'll make 300 or 1,000 or 10,000 different calculations as to what each person's damages are. My idea, and this is not something, we're probably 6 months or a year away from this idea, it is to motion the court to appoint what's called a special master, who has like a depth of experience. They're a court appointed specialist whose job it is to come in and calculate the damages for each person. Does that make sense?
Yes, sir. Thank you very much.
Of course. Nina, I'm not sure if your hand is still up from your past question or if you had a new question. All right, and
I forgot to do that.
it's
Sorry.
okay. No worries. It's and then Jennifer, your hand is still. All right. I think I have answered all of the questions. We continue to, and I'm so grateful for the turnout today. This is the biggest turnout we've had for a while. I think I've maybe hope to maybe poke the nest a little bit by doing all of this activity, and I'm grateful because the more people that come into these things, the more people that know about it. I will send out this video again, like I always do. I'll send out the video. I'll post it on the group's website, and then anybody that you know about that maybe benefit from joining this case, you can let me know. Jennifer, you had another question.
Sorry, Joe. I was trying to adjust my icon to lower hand.
No worries. Okay.
Sorry about that.
No, you're great. No worries. I just want to make sure I'm not leaving anybody hanging.
Appreciate it.
And again, once I've corresponded with you, through the portal or text messages, if you have like a very, an individual question, I think anybody who's used that portal knows that I'm fairly responsive. I should say I'm extremely responsive. There was one exception, a gentleman whose text got buried for like a couple of weeks, but I just raised him back to the top. But I'm usually very responsive in the text and email because the red dot on my screen doesn't go away until I respond. Nita, did you just raise your hand again?
Yes, actually, I'll be very short. I just wanted to say that there was a similar lawsuit many years ago. Have you heard about that?
Yeah, 2015. I've actually incorporated it into my case. So that was a case that the Lee case, Lee versus the United States, was a 2015 case that went all the way up to the Court of Appeals. That was an example. So I'm really grateful you bring that up because that is an example about the importance of understanding how to sue the government in this court. That case was brought as what's called an SCA claim, Services Contract Act claim. The argument was that the government wasn't paying these independent contractors as sufficiently as under the Services Contract Act, what's called prevailing wage. the Judge Leto at the Court of Federal Claims dismissed that claim, and it went, and then they amended the complaint and brought in these overtime and minimum wage claims issues, but did not bring it under the Fair Labor Standards Act. They didn't plead the Fair Labor Standards Act. So then when it went up, and then that case got dismissed and went up to the Court of Appeals, to the Federal Circuit, the Court of Appeals affirmed, and they never went to the Supreme Court because the court decided that in that instance that the Services Contract Act or Davis-Bacon did not apply to the federal government, and the Court of Appeals agreed. I brought it under the Fair Labor Standards Act. The government again argued that the FLSA does not apply to the federal government. And in this instance, the Court of Appeals agreed with me and disagreed with the government. And that's why we are where we are.
Yeah, he was my co-worker, actually. We worked in the same office.
Yep.
And he was trying to have others join. But at that time, many of us were very reluctant because the situation was different at that time because we were still working. It's not like right now where we don't have a job. At that time, we had a job, and we didn't want to lose our jobs or face retaliation. So he ended up getting signature of only one other person from one East European service. So,
this is one of the things I think the government in this instance miscalculated. They summarily fired a bunch of people. Many people ended up on airplanes having to fly back to their country of origin because they were here on immigrant visas, and the moment they were fired, then their visa status became threatened. And I argued this, by the way, in my motions for equitable tolling and equitable estoppel, is to say, look, of course these folks were silent. They were silenced by fear, because if they raised their hand, if they raised any noise that they were the W-2s, then the government would threaten that they were threatened to firing them. They were gonna get fired. They were going to get stuck with excess procurement costs, and many of them were suffering deportation threats.
okay. Thank you.
Of course. And I think you have your hand up next.
Yes, sorry to keep me long, but I don't think I ever heard you mentioning, but I'm sorry. Is Judge Lambert's decision, to void whatever Kerry Lake has done, has any benefit to our case?
No, Judge Leto's case was adjudicated completely back in 2018, and I did use it. Honestly, because one of the ways you can, again, you guys are getting into like second year of law school now, but one of the ways that you can shoehorn a case in under equitable tolling is to show that there was a defective pleading in the past. So I argued that the 2015 filing was in fact a defective pleading because it brought the wrong statute. It's one of the issues that I raised. Now, Judge Summers summarily just said he didn't dispute any of it. He just said none of it was good enough. And that is the issue that's sitting at the Court of Appeals right now, is for the Court of Appeals to rule. Look, this is a factual issue. This is up for the court to decide. And again, if the Court of Appeals rules in my favor, and it should. I mean, the people that I've, if it does, then that weakens the position of the government sufficiently that I'm hoping they'll come to the negotiating table and want to negotiate a settlement, is what I'm hoping. All right. Did that answer your question? And you do well?
Well, I was talking about Judge Lambert's decision.
So say that again.
Judge Lambert's recent case against the USAGM brought by the full-time staff of that.
You're talking about the Washington D.C. case, the U.S. District Court for the District of Columbia, right? And that case ended up getting it doesn't negatively impact our case because David, who brought that case in D.C., was bringing it under a different statute. He was arguing that under the organic statute of the USAGM, then the government did not have the right to just shut that business unit down. The trial court agreed with them, and then the government moved to stay the effects of the decision, and the Court of Appeals agreed with the government, and then they filed a motion for a hearing on Bach, and the motion for a hearing didn't reverse the trial. They did the motion for a hearing, which is pretty rare for them to do in the first place. And then I think they took that case up to the Supreme Court. But again, it was only as it relate, that case only dealt with the executive's ability to shut down a part of its, and again, the trial court 100% agreed with the plaintiff's position on that. And it's just stayed at this case, is what I understand. But I'm not involved in that case. I'm familiar with the attorney that is, and he and I have spoken, and I've asked that we maybe try to cross pollinate, because I think the case that I have going on at the Court of Federal Claims is the way to get this thing done. That's what I believe is true.
To be more specific, the ruling was that whatever Carrie Lake did, the CEO appointed by Trump, the court decided it's void because she was not appointed.
Sure, that's not a proper appointment, right?
I was wondering if that has any benefit to our case.
Well, I mean, what should happen if the stay is lifted is that should mean that the agency has to bring people back in and get people back to work. And I think that has happened in some small degree, not universally, but it has happened in some small degree. What the damages picture that I've got going on at the Court of Federal Claims will only be affected by the mitigating circumstances of people coming back to work. The amount of money that if you weren't retroactively paid, then I'll get that. You'll get that. Now, some people were retroactively paid if they weren't paid the liquidated damages. So the liquidated damages provision will still be in effect at my case, which is that two times anything we lost is what liquidated damages means. That help?
Thank
you. All right. I think I still have two hands up with Jennifer and Jody. I think Jennifer's, your hand was up first.
Sorry, Joe. I have lower hand and it's still showing on your hand as raised.
Listen,
so
I'll help out.
Forgive me.
No worries.
Beg your pardon.
No, you're great. And then Jody, your hand is still up. Do you still have a question? All right. I am going to, listen, I've got some chats going on here. Q&A that I missed. Has the Court of Appeals set up a court date for the 2027 and how's retaliation? So the retaliation claim, the retaliation claim is at the Court of Appeals right now. There is also retaliation claims pled in the FTCA action, which is the ones that are currently at the agency. And the answer to the first question is they have not set what the next thing will happen is an oral argument. I expect the oral argument will happen either in the late fall or the winter. And what's really good news is that the Court of Appeals generally, at this particular Court of Appeals for the Federal Circuit, generally issues a written decision within about 30 to 45 days of when we do oral argument. And in the last instance, they issued the published opinion, and it was game changer in this space. And I think the Court of Appeals fully expected the government to go to the Supreme Court, but they did not. Jason, I will answer your question one-on-one when we get going. But nothing. One question about automatic win. It's unfortunately with this particular court, I don't know that things that should be an automatic win are not always, because this court has been very selective about the law that is applied. Are you aware that a firm called Themis filed a similar lawsuit to the 2015? That was the case we just talked about. I'm all ears, so can you go after 10 yards as a tort? That would be a separate lawsuit against a private actor who's going to point fingers at the federal government. So we're already there. If I pass away, who would take over my case? I just got done with my physical, so unless I get T-boned by a truck, I should be in good shape. But we do have backup lawyers on this case named Forrester Haney. They're working with me. There's a big employment law firm in Dallas, Texas. They don't know very much about suing the government. I've been teaching them since we've been doing this. David Sides is the person we're talking about. Yep. So if I get T-boned by a greyhound, then they will take over. They're already familiar with the case. We meet every other week and update them on what's going on. Many of you have seen Matt McCarty's. I'm saying his name terribly, but he's the partner at Forrester Haney, who's signing all of your engagement letters at the FTCA action. And their law firm would step in the event that I get, eat one too many cheeseburgers or something terrible happens. That looks like all the questions that I have so far. All right. And with that, you got more than you guys bargained for today. I will set up another meeting, try to keep us back on that at every other weekend, every other Sunday type of thing. We haven't been able to do it because of holidays in some instances, like 4th of July and Father's Day and Mother's Day and all that stuff. But I think we have the next big holiday I think we have is Labor Day. So we should be able to get a couple of meetings in here between now and then. Keep, as you have issues coming in, just use the text message, the portal, and of course emails. If you have questions, you can use that. That's just, email is maybe the mechanism that I'm most likely to. I get about 250 emails a day, so that has a higher chance of slipping through the cracks than a text message through the portal or text to the Clio software, which is that 833 number that you guys see, or a message through the portal, which I can't lose. So, all right, with that, I will give you guys your Sunday back. Thank you for joining, and then be on the lookout for this email to circulate, not the email.
Thank you, Joe, for everything. Appreciate it.
Of course, be on the lookout for the video to circulate when we're done.
All right. Thank you very much.
Thank you,
Thank you so much, Joe. Thank you. Bye-bye.
Happy Sunday.
Joe.
Bye.
Thank you, Joseph.